So did you see the news yesterday?
No, what are you talking about?
I'm a cat lawyer.
You're a cat lawyer?
I'm not a cat lawyer. I'm not a cat. I'm a lawyer.
I know, Danielle, I know. What are you talking about?
Come on. Like my mom saw it and all my college friends. Really?
No,
you didn't see
yeah,
this?
I'm teasing you. I know you're not a cat. I know you are a lawyer, and I saw the video. I think everyone on Earth saw the video.
Mr. Ponton, I believe you have a filter turned on in the video settings. You might want to
we're trying to. Can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
I can see that. I think if you click the up arrow next to it.
Okay. Good morning.
Good morning, Judge. How are you?
I'm very well. Nice to see you both.
Yeah, thank you so much for doing this. I was just telling Zach, your video went viral in an unbelievable way. I heard from my mom, my aunt, all of my college friends, none of whom ever follow anything legal. So we're just really excited to have you. So thank you. We do really short form videos for court staff on access to justice topics traditionally. And so thought this would be really fun we do Friday surprise emails, and it would be really fun to have a video with you. So thank you for being game to do this.
My pleasure. And we can absolutely focus on access to justice and tie all of this together because it is directly connected. Absolutely.
All right. Excellent.
Well, how do you mean? Let's explore that a minute.
Yeah.
Well, our goal is to bring everyone into the system who needs to come in, whether we need our juries to be reflective of our communities and truly reflective of our communities. We need diversity of participation, but we also want every person who needs justice to have the opportunity to seek it. And, in these rural counties, my area is 20,000 square miles. So it's enormous, and people have to drive sometimes 2 hours to get to their own county's courthouse. That's tough. You have to have a reliable vehicle. You have to have daycare, take time off of work. Some people can't afford to do that, and so they just let those things go. They give up their rights because they don't feel like they have the ability to pursue the remedies. And what we have found through the way that Texas has responded by creating these virtual courtrooms is that we are seeing greater participation than ever. Our jury panels are more diverse. We're seeing more pro se parties come in. We have people connect to their hearings from the break room where they work. I've had nurses, I've had people at Walmart, I've had fast food workers who will just walk outside the building and hold their phone up and participate in a hearing for 15 minutes and go back to work with it just on a smoke break. So it has had a dramatic effect on improving access to justice in Texas. It is unquestionable, undeniably true.
Mm. Well, I mean, it's wonderful that people don't have to take time off work and find childcare and travel, and all those innovations are a result of the pandemic, which is not probably something anyone anticipated. They probably also didn't anticipate that some people would have these kind of filter issues or show up in court and maybe not be quite prepared to be in front of a judge. So you have a serious job. Court's a serious place. It's undeniable that what happens is a little funny. So how do you balance the two, the humor and the seriousness of what's going on?
When you do something over 1 million times in 10 months, you're going to see just about everything. Everything that can go wrong will go wrong at some point. And Texas has had over 1 million virtual hearings. I've had over 1,000. I don't know what the number is. We're probably sneaking up on 1,500 at this point. That's a pretty good sample as well. So I've seen a lot of funny things. But I remind myself every single time I sit down and turn on the camera that this is not me making a blog or making a YouTube video to be funny. I'm the judge, I'm the court, and every person who appears before me has spent a lot of time and a lot of money and a lot of angst to get ready to present whatever it is to me. And I am very cognizant of the fact that if I make it appear it's not important, or if I make light, or if I joke with one lawyer and not another, or if I tease a lawyer and not another, that sends a message, and not only to the litigants, but to everyone who's watching our open and public courts. And this is a solemn moment. These are solemn proceedings. My job is to bring dignity to the bench, and I require that of my lawyers. And if you see the way everyone acted in that hearing, I hope you were struck by the fact that everyone remained professional and dignified. There were a couple of smiles, but they weren't cruel smiles. They were just sort of smiles of acknowledgement, if you will. They showed exactly what's great about Texas lawyers, is we're there to do a job. This was a courtroom, and everyone treated it that way. And I'll tell you, right after the video clip that you saw, right after I cut that point, I came on camera and I walked the lawyer through how to turn off the filter. And the instant it went off, I called the case and we had the hearing with not so much as a smile or a comment ever by anyone as to what had just happened. So we know these things will happen. You've heard the stories about what other courts have experienced. We just roll with the punches and keep right on going.
No, that's great. I think everything you said is important and wonderful, and I think the pandemic is a disruptor that can allow for increased accessibility and public education of the court system, so it's all great. But I also know it's a really stressful time, and that YouTube clip brought light and joy to a lot of people, so thank you for that too. It really is like a zeitgeist kind of moment, and we're really excited to get a chance to talk with you and also celebrate courts and the great work that you do in the same time. So thank you.
You're welcome. This is a really tough time, not just for the United States, but for the world. And people are sick, they're scared, they're having friends and family members die, they're losing jobs, they're trapped at home, they're homeschooling kids or remote schooling their kids. And there's an incredible amount of anger, political anger that our country has suffered through now for months. And it's going on today. Yesterday, that proceeding started. And this happened around 11 o'clock as that proceeding was starting. And I think we just had a pent-up malaise, and people just needed an outlet. And I don't know how else to explain something as silly and innocuous as a 48-second snip getting 100 million laughs. The whole world laughed at once. And it's a wonderful thing to think about. Is, we joke sometimes that if something important happens in the courtroom, your ears pop because everyone inhales at the same time and it sucks all the air out of the room. Well, that's kind of what happened here, but in reverse. It was 60, 70 million people so far have laughed out loud at that video. And what a wonderful thing to raise the morale of the entire world all at once over something so harmless and without a seed of cruelty at the center, which much humor has. Every one of us knows that could have been me. That could have been my child who turned on that filter. And you can't undo it because the internet is forever. So I think everyone had a moment of relief and levity, and it's just objectively funny. You can't help but laugh at that moment. So I'm honored and thrilled to have been a small part of that. I would have been happy just to have seen it myself, to be honest. What a crazy experience it is.
Yeah.
Well, thank you for giving us some of your time and explaining it to our dear viewers. I think people really enjoyed the clip, as you've noted. And we love that you can tie it to access to justice and really bring it home for our court staff viewers, because we think that's incredibly important. So thanks.
Yeah, many thanks.
My pleasure.
And
thanks for watching.
For more Tiny Chats, and to make sure you don't miss a single episode, be sure to subscribe at ncsc.org/tinychatsubscribe. Thanks for watching, and be well.
Teri Teri Deal joined the National Center for State Courts as a principal court management consultant in 2019 after several years of experience working both in juvenile and family court research settings and in direct service to system-involved youth and families. Her work at the National Center focuses on child, youth, and family justice with a specific emphasis on implementing and evaluating court practices, continuous quality improvement, and systems change efforts. She recently completed a study of virtual child welfare hearings across 5 states and 17 jurisdictions. And actually, there were a number of judges in Nebraska that participated in that study. And she leads the Racial Justice Data Change Collaborative, a learning collaborative focused on supporting state and local child welfare systems to view data through an equity lens. Prior to joining the National Center, Ms. Deal spent nearly a decade as a researcher at the National Center for Juvenile Justice, the research arm of the National Council for Juvenile and Family Court Judges. Her work there primarily focused on supporting juvenile justice systems, courts, agencies, and programs to collect and use data to improve outcomes for youth and families. Ms. Deal studied at the University of Pittsburgh and the University of Virginia, and she is currently pursuing her PhD in community engagement at Point Park University, researching school justice partnerships. We are excited to have Teri talking with us today about the virtual hearing study that she has recently completed. Please help me welcome Teri Deal.
So I was really pleased when that I get to go after that tiny chat, because I think that the judge in that tiny chat brought up some really important things to think about. If we go back in our minds to the beginning of the pandemic in March 2020, the court community really came together and did a lot really fast to get things moving for kids and families. And so I think I would just like to take a second and appreciate you guys for that and give yourselves a round of applause, because the courts really worked really hard, and that's something to be proud of. And this study that I'm about to tell you about was very exploratory. We at the National Center just wanted to see what was happening. So we don't know yet if what we did as the court community benefited children and families, if it made things take longer, that's to be seen. And I'll talk a little bit about our next steps with the study at the end of my presentation today. But what we're really going to talk about is all the things that we learned from observing these virtual hearings across the 5 states and 17 counties. I'm going to be showing you 2 different types of data today. I'll be showing you both data that encapsulates all of our sites, as well as data that is Nebraska specific. So again, this is exploratory. I'm open to any questions you have, so you can ask them as I go, or we'll have time at the end too. So when the pandemic first started, and courts across the country were kind of scrambling to figure out what to do, we heard a lot about the mechanics and the technology that those kind of decisions that courts were making. But what was missing was what families and kids and court users were experiencing in this switch to virtual hearings. So with funding from Annie E. Casey and the Casey Family Programs, we developed this study to do 2 things. Number one, we wanted to find out what was the experience of youth, family, and court users in virtual hearings. And secondly, we wanted to see to what extent are judges able to implement what we know about quality dependency hearings virtually. So those are the research questions that we started out with. And at first, we didn't think that any courts would sign on to participate because everyone was so busy and figuring things out. But we were actually very lucky to have more courts than we even anticipated participate. So you can see here are 5 states. And in Nebraska, we had 5 different judges that we observed. And we had 2 judges on the western side of Nebraska, and we had 3 judges here in Omaha and Sarpy County that we observed, and then 3 judges in Michigan, and we had 2 different courtrooms in Washington, a number of judges there in 3 different jurisdictions in Texas. And then you see this maroon county, Pima, which is Tucson, Arizona. And that was our only family treatment court that was in the study. And the data from the family treatment court's not in this presentation, but we actually did a webinar last Friday, and that's available on the NCSC website. So if you're interested in that, that information, let me know and I can point you towards that. We did a lot of data collection in this study because it was exploratory. We weren't quite sure what we were going to learn and what we were going to find out. So our data collection methods were interviews. We interviewed every judge that participated in the study. We interviewed some attorneys actually in Nebraska in communities where there weren't enough attorneys to survey. We did some interviews and focus groups. We interviewed youth. Unfortunately, not as many youth as we would like, and that's something that we hope to improve in our next round. But some of the youth that we interviewed were from Nebraska. We did surveys, parent surveys. Again, this is one of the things that I kind of am kicking myself about in hindsight, is that the ways that we went about trying to obtain information from parents, I think we could improve on, and that's one of my goals in the coming, in the next phase of the study. And also, I think we did an electronic survey of how comfortable people were with that technology. So clearly, the people that were responding to an electronic survey felt comfortable enough with technology to respond to an electronic survey. So I feel like we're probably missing a whole bunch of people, of parents who don't feel comfortable enough with technology to respond to our electronic survey. So we have some strategies that we're thinking about for the second phase to increase the number of parents that we get survey responses from. We also did surveys of attorneys and surveys of caseworkers, and we actually we have more surveys with caseworkers from Nebraska than any other state. So thank you for that. And overall, we observed more than 370 virtual hearings across the country during this time, and 36 virtual family treatment court hearings. 61 of those hearings were here in Nebraska. And I got this question the other day, so I'll answer it in case someone else has it. We interviewed youth that were 15 and older. So so that's the information that we have from kids are all older adolescents. Our timeline was truncated, but we were hoping it was even going to be shorter than this. We started recruiting courts in October 2020, looking at states that we knew were up and running with their virtual hearings. We interviewed all the judges and kind of prepared the data collection in October and December. And then we were going to collect data from January to March, but we actually had to extend that to May. Our goal was to get 30 hearings in every jurisdiction, and we weren't able to do that because some of our jurisdictions ended up going back in person or hybrid before that. So we ended data collection in May 20. We also tried to extend it to get more youth and parent participation. So one of the things that we did in our court observation that was really important to us was to identify how often the pandemic came up in hearing conversations and discussions during hearings. One of the main tenets of being a trauma-informed courtroom, of course, is transparency. And for us, I think it was important to see, are we talking about the pandemic in that we are now using virtual hearings because of the pandemic, and it's a hard time for everybody, and kind of acknowledging that it's different and acknowledging that it might be people are experiencing challenges. So we actually found only in about 16% of all of our hearings did the pandemic come up in discussion. And often the most frequent times that it came up was barriers to accessing services, difficulties communicating with incarcerated parents, which actually in some of our jurisdictions, the pandemic improved in communication with incarcerated parents because jails and prisons had to implement that technology. But we also saw the opposite. In some places, jails and prisons were unable to connect in court hearings, and parents who were incarcerated weren't able to mute their phone, and often that was a distraction in hearings and caused some difficulties. We also heard about parents, children, and caregivers actually having COVID. In fact, in 2 of the hearings of the family treatment court, the parent actually joined from the hospital, which was startling for me to witness, but you could, they were there and they made it to their hearing.
Okay.
And finally, which I think we've all thought about, is these barriers to visitation. That was a 4th kind of common theme that we heard throughout the pandemic in the hearings that we observed. But our biggest takeaway from the study is that every courtroom, even courtrooms within the same courthouse, did their practices of virtual hearings a little bit differently. All of our states, except for 2, were on different platforms. And all of them were on different platforms, and they use different practices, which we'll talk about in a moment. Just for background, most of the hearings that we observed were review hearings or permanency hearings. The average hearing length across all of the hearings that we observed was about 21 minutes. But you can see this range here. We had some hearings that were only 3 minutes, all the way to some that were over 43 minutes. And the wait time, average wait time, is 8 minutes and 22 seconds. But that number is kind of meaningless because the wait looked very different depending on what state or jurisdiction you're in. We saw about 3 different ways that courts were scheduling hearings. One was that a courtroom might have one Zoom link or hearing link for the whole day, and people would just join as it was time for their hearing. We also saw some courts that had an individual or a unique link for every hearing. And the third way is that we saw some courts that were scheduling multiple hearings at the same time. The Zoom room would be open and there'd be dozens of people waiting for their hearing in the Zoom room, and they just turned their camera on when it was their turn. So we saw a lot of differences across our sites and how they were doing that scheduling. And so some of that wait time number is inflated because people waited a long time who were in that kind of environment when they were in I'll call it a mass Zoom room environment waiting for their hearing to start. So that's why you can see that range goes from 0 minutes, because most of the time if it was a unique hearing or a unique link, people didn't have any wait time, to 40 minutes if they were in kind of that multiple hearings at the same time. We saw many differences, and these are the kind of big themes, which makes it hard for us to really talk in aggregate, but you'll see a little bit later. I talk a lot in ranges about what we saw because we did see the continuum. I spoke about a continuum of how people scheduled hearings, but we also saw a continuum around expectations of camera use. We had one court where the judge was the only person ever on camera. No one else ever turned their camera on. And that was the way that that all of the hearings were in that court. We had another court where the judge insisted that everyone have their camera on all the time. And it was actually in the chat room pinned, like you must have your camera on, it's a requirement. And we had everything in between. Most of the time, there was no discussion about whether your camera was on or off. It was however you showed up to the hearing and the hearing would progress. But those expectations really were, there's a wide range of that. We also saw a lot of differences in the judge's camera placement. Most of the time, the judge that we observed was using a camera on top of their device or on top of their camera, so you could see a front view of the judge's face. But we did observe in some hearings where the camera was across the room, sometimes looking through a plexiglass barrier, and you might see a profile of the judge. And in some courts that didn't have the technology to do a front view of the judge speaking, it was a security camera kind of going over the top of the judge's face to the front of the room. So you can imagine that that does create a very different kind of feel for being able to connect with someone virtually if you aren't being able to even see their face. So we did see a range of that. We also saw a range of instructions for participation. In our parent survey, we learned that most parents were receiving their instructions from attorneys. And sometimes that those instructions might just be a phone number. And other times it was the actual instructions that the court had given to the attorney to give to the parent. We did see some courts that were actually drafting instructions to make sure that every party got the same instructions on how to join. And then levels of formality, we saw a range about, I guess I'll say, what kind of, how formal a judge was requiring parents to be within the hearing. I think we walk a really fine line when we talk about virtual hearings and the difference between meaningful engagement in a virtual hearing and convenience. So the judge on the Tiny Chat, talked about it's great that people can join from work and join from, when they're out when they're out at the store or things like that. I think we in the child welfare world need to balance that convenience with meaningful engagement. We know the outcomes of cases are much better when we have meaningful parent engagement in the courtroom. And I think that while it is great that parents don't need to incur transportation costs and time spent being transported to or going to court, we want to make sure they're in a place that they're safe and that they have the privacy to talk about some really sensitive and important issues. So in our study, we did see parents at work. We saw parents doing hearings while they were visiting with their children. We saw parents at the store. My favorite example is a dad who was plowing snow. And he, at the beginning of the hearing, said, "I'm plowing snow. If I don't answer right away, that's why." And I just have to question, can we meaningfully, are we getting meaningful engagement from parents if they're in that distracted area? So that's something that we're going to be looking at in the next phase of the study as well. And then inconsistent practices for interpreters. This is a question I get asked all the time about interpreters in virtual hearings. And we had about 4% of our total hearing observations had interpreters, and actually many of them were here in Nebraska, in Omaha. And we saw a big range about how interpreters participated in virtual hearings. We saw some interpreters in person with the person that they were interpreting for. We saw one in particular, which I thought was effective, was the interpreter was virtual, muted themselves and called the parent. And so they were able to talk simultaneously when the judge or lawyer was talking with the parent. But then we also saw where there was asynchronous interpreting. So someone may speak and then the interpreter would speak, and then someone else would speak and then the interpreter would speak. And in those instances, you could almost see people kind of rush through. You could see attorneys kind of rush through what they were saying, or people try to move forward because it felt like the hearing was taking a long time. So we are going to be working with our language access department at NCSC to kind of learn more about what those best practices for virtual interpreting should be. And then finally, the biggest other big difference we saw across all of our courts was the person in charge of technology. Some of our courts had an actual person, it might be a clerk or an assistant, who was making sure the right people were in the Zoom room, kind of making sure everyone's audio worked, that everyone was there. But in a lot of our courts, that was the judge's responsibility too. And so that might mean, or only the judge's responsibility. So that might make the hearing last longer. That might make there be less time for discussion within the hearing time. So we did see quite a range of that. And so the biggest controversy, I'll say, that has come out of this observation of virtual hearing so far is the video versus audio controversy. There's a lot of thoughts about which is better, and we hear both sides, right? In transparency, personally, I think video is better because I want to be able to see a person when I'm talking, and I want people to see me. If you've ever joined a Zoom meeting, and I mean, we've all been in a million Zoom meetings the past year and a half, right? If you've ever joined one and you don't have your camera on, or someone else doesn't have your camera on, it's almost like you're thinking, well, what are they doing? Who's that? Or are they really paying attention, right? You have these kind of implicit thoughts that happen about when someone doesn't have their camera on. And I think that is something that we're trying to learn more about, how that happens, or what happens in the courtroom when someone doesn't have their cameras on. We also have the other side of people saying we don't want parents to have their camera on because there might be something in the background that we don't want someone to see, right? Or we want them to have their privacy. So there are different kind of camps around this issue. And so we definitely need to do some more investigating about which is better. And we will be working with a social psychology organization for our next phase to really think about what are the benefits and impacts of camera use in the courtroom, specifically for parents. There is some existing research before the pandemic about video testimony actually being less perceived as less credible, especially for children. And so that's something that we need to think about too, how a video testimony might, are there times when a video, when it's better to be in person versus in video? And we did hear that from a lot of our study participants, that there are specific hearing types that should be in person, and a lot of states in their regulations around virtual child welfare hearings are now making it individual hearing types that are permitted to be virtual. So the next several slides are about who was present in the hearings and how did they show up. And so the big gray bar shows the range of all of our sites together. So in one of our sites, only 10% of the time was a mother present, and in another one of our sites, 80% of the time a mother was present. So that I include that gray bar to show just the range across all of our sites. There was so much difference. But the blue dots and the numbers are Nebraska. So that's all the 61 hearings that we saw in Nebraska. So of those hearings in Nebraska, about half the time a mother was present. When a mother was present, 60% of the time she was present by video. Most parents, when they are present by video, are using a smartphone. And so that is going to look much different than somebody who's joining by a computer or a stationary device, right? So if you think about yourself on the screen, that square doesn't move if you're joining by your desktop or laptop. But if you're joining by your phone and holding onto it, you can imagine that that's kind of shaky. And so that can be distracting to other people in the hearing, but it can also cause some kind of internal thoughts about how someone is presenting themselves online. And if you have never joined a virtual hearing by your cell phone, I really encourage you to do it because it looks totally different on some platforms than it does when you join by device. So when we join by device, we can see everyone. Sometimes when you join by phone, depending on the platform, you can only see the person talking. So you might not know everybody who's in the room or who they are. you might not have access to the chat function if people are using that. So I just encourage you to take a peek at a hearing by your cell phone if you haven't done so yet. Back to this. And then in Nebraska, about 38% of the time a father was present, but when a father was present, they were present by video 70% of the time. And that kind of trend of fathers using video more often than moms, slightly more often than mom, is something that we saw across all of our states. And then we also looked at how often children were appearing, and this was any age child because this was from our observation. So you can see we had a range across all of our sites, but it was still pretty low. In all of our sites, we had some where children were never present, and we had some where about 50% of the time a child was present. In Nebraska, about 1 out of every 5 hearings we observed had a child present. When children were present, 77% of the time they were present by video. Often they had a support person with them, whether it's someone at their placement, a foster parent, in some instances, someone at their school. So usually a child or a teenager wasn't joining by themselves, but they were present by video most of the time. We also looked at this for attorneys, all different types of attorneys. And I think the big takeaway here is that court attorneys, court professionals like attorneys and caseworkers are almost always present by video. We saw this very frequently and more so than parents. So when somebody was not present by video, it was usually a parent. So you can see here, 76% of the time the state attorney was by video, 88% of the time the mom's attorney was by video, 92% of the time the child's attorney was by video. So most of the time professionals are joining by video. And attorneys are most likely to use their own personal cell phone or a personal device to join. And then we also looked at other people who might be in the hearing. So I talked a little bit about agency already, but for CASAs here in Nebraska, about 30% of the hearings we saw had a CASA, and 60% of the time they were by video. Caregivers in Nebraska, almost 90% of the time they were present by video, and that's higher than we see in a lot of places. And so that caregiver could be a foster parent, a placement provider, a kinship caregiver. We also looked at relatives because one of the benefits I think that's been touted of virtual hearings is that it allows for participation from support people who may not be able to participate in person. And so we didn't see very many relatives, but in Nebraska, about 8% of our hearings had a relative, and 60% of the time they were present by video. And then here in Nebraska was one of the highest percentages of interpreters we saw. 8% of the hearings that we saw here had an interpreter, and 80% of the time they were by video. We only had one hearing here that had a tribal representative present, and they were by video. So the next few slides that I'm going to go through, each dot represents one of the courts that we collected data in. And as we embarked on this study, we wanted to start off by thinking about what would a trauma-informed hearing look like. And when we talk about trauma-informed court hearings regularly, we think about transparency and safety. And so what are some practices that we might want to put in place, or we would expect to be in place in a virtual hearing, that would be transparent and also create a sense of safety? And so we identified a few of these, one being confirming that all parties are present before the hearing started, confirming that everyone's sound worked, providing instructions, which I talked about a little bit earlier, and then asking parties' location. So each dot represents a hearing, a courtroom. So you can see in more than half of our courtrooms, they confirmed all parties were present before they started most of the time. A little bit less of the time did they confirm everyone's sound work. And I actually personally observed a handful of hearings where we were a good 5 to 10 minutes into the hearing before we realized that we couldn't hear someone, or they couldn't hear us. Or they couldn't hear the hearing. So that's something that can be done real quick at the beginning of the hearing, just to make sure people can meaningfully engage. And then providing instructions for the platform. I talked previously about providing instructions ahead of time, but there were often times during the hearings where people needed some kind of instructions, even as something as simple as how to unmute themselves. So just going through a couple instructions at the beginning now might be a different situation because everyone's been using virtual kind of platforms for a while. But even back last December, some parties might not know how to use that. So providing some general kind of tips at the beginning would be helpful. And then asking parties' location. We didn't have any courts that routinely did this. One court that would do it if a problem arose, but often that was not a question. And I think this goes back to what I was mentioning about making sure that we have that parents and kids, for that matter, are in a safe and private location to have some meaningful engagement in the hearing. And so I think there is an opportunity there to ask where someone's joining from. Do they feel like they're in a private place? It might be great that they can join from the break room at work, but do they feel like they can really talk and hear and be able to say what they need to say and with that sensitive information in that location. Some of the other things that we considered was acknowledging the virtual environment. And I think this goes both to transparency and kind of authenticity. The virtual environment is weird for a lot of people. And I think the pandemic is weird for everybody, right? So I think just being transparent to say, this is different. This is a different way for us to engage. I hope that one day we'll be in person again, but this is still a hearing and this is how we're going to proceed. So kind of acknowledging that virtual environment. We had one court that did that often, and some courts that did it some of the time. We also tracked whether courts encouraged parents to be on video or youth to be on video. We didn't have any courts that did that consistently, aside from the court I mentioned that had that in the chat. But we did have some courts that if the need arose, if someone was talking, they would say, can you turn your video on? Are you able to? And most of the time the person was able to. So then we also looked at, the National Council of Juvenile and Family Court Judges has for years in their enhanced resource guidelines identified kind of best practices in judicial engagement. And so part of our study, we wanted to see if those practices were able to be implemented by judges in the virtual environment. And kind of the short story is, yes, they are. We saw a lot of judges doing things such as explaining the purpose of the hearing, speaking directly to the parties, addressing people by name, giving people the opportunity to be heard, asking if they have questions and if they understand next steps. I kind of flew through that because the answer is yes. Those kind of practices are very possible in the virtual environment. Now we don't know if they make the same difference as they make in the in-person environment. That's yet to be seen. And hopefully now that we have some cases that started in person and ended virtually, or went start to finish virtually, or started virtually and ending in person, we'll be able to tease out if there are any differences. That's in the next phase. So I wanted to take just a minute to talk about the attorney survey. Oh, I didn't know you could see that little box. Let me try to move me. Okay. So this information about the surveys, I have pulled out just the Nebraska information here. So we had 31 attorneys from Nebraska that completed our survey. 93% said it was easy or very easy for them to connect to virtual hearings. And they were taking the survey, I would say January, February, March 2021. Most report attending by video by their personal device. And 3/4 of them say that less than 20% of their caseload has trouble accessing virtual hearings. One thing that we heard in Nebraska from the attorneys was 71% of those who completed the survey said that they have noticed a decrease in the quality of communication during virtual hearings. So that might just be the amount of communication or the ability to connect with people virtually. One of the things that we did look at in our court observations was the opportunity for parents and kids to communicate with their attorneys during hearings, because obviously that's something that was kind of lost. And we heard from a lot of attorneys when previously they could reach over and like nudge their client or whisper in their ear or grab their hand if they needed to. They kind of weren't unable to do that in the virtual environment, and attorneys missed that. I will say that I heard in our focus groups and in our and in other conversations we've had with attorneys. But in most of the courtrooms that we observed, we observed parents communicating with their attorney. Now, we didn't go into breakout rooms. Often that happened during breakout rooms. We just acknowledged that there was a breakout room. So we heard most of the time that communication occurred by breakout room or text message. And so we could tell that if an attorney was like, well, she just texted me, or told a client to text them. So that happened occasionally. And 45% of attorneys in Nebraska said that they were able to confer with their client almost every time or every time that they needed to. We did not, in any of our states or any of our sites, see youth communicating with their attorney during a virtual hearing. We didn't have very many hearings where youth were present, but we did not see any of that communication. We also had, as I mentioned, the most caseworkers of any state was Nebraska. So 63 caseworkers here in Nebraska responded to our survey. And again, 92% of them said that it was easy or very easy for them to connect. They were most likely participating by video with an employer-issued device. And 73% of them said that less than 20% of their caseload had trouble. So very similar to what we heard from attorneys. The two major barriers that they saw, 43% said that they actually had clients who didn't have a device to connect to a virtual hearing, and 41% said they had a client who did not have any internet connectivity. So that kind of goes to our next thing that we looked at, which was technology issues. And 16 out of our 17 courtrooms had at least one technology issue. So they were across the board in every courtroom that we observed hearings in. And about 1/5 of the hearings we observed had a technology issue. So about 1 out of every 5. And if you think about the last 5 Zoom meetings you've been into, I bet you're going to think about having at least one where you had some kind of internet issue. So the kind of technology issues that we are talking about are whether someone lost Wi-Fi connection, or their audio cut out, or they froze, or someone even had difficulty accessing the platform or using the platform. So a lot of the time in arguments against virtual hearings, we hear people concerned about the technology issues, and they are present, but we did not find them present any more often than you would in your day-to-day life. And I also want to note that of all of the technology issues throughout the whole study, attorneys were the source of 1/3 of them. And parents were a source of 1 out of every 5, 20%. So I say that to say a lot of times when we think about those technology issues, we immediately go to the parents or the kids having them. But professionals who spend their entire day in courtrooms also experience some of that. So that's why I say that, not to make fun of any attorneys who are. So finally, kind of to boil it down, in our surveys of parents, attorneys, and caseworkers, we asked what worked well. And across all adults that we asked this question to, the number 1 and 2 reasons were, I don't have to go anywhere, I don't have to spend any time traveling, and I don't have to spend any money traveling. My clients don't have to spend any time traveling, and they don't have to spend any money traveling. That's what we heard. That's a huge benefit to them. And what we heard from youth in the interviews, now there were a smaller sample, but what we heard from youth in the interviews was not only that they didn't have to leave their house, but also it reduced their anxiety. That did not come up as a top reason for any of the adults on the survey, even though that was an option. And I think this might also speak to, I think we heard a little bit from the panel earlier today, youth want to see what someone looks like. They want to know who somebody is. And in the pandemic, there was so much social how come I can't say that word? People were isolated. Thank you. There was so much of that for young people who maybe weren't in school. And now we're also talking about young people who are separated from their family. So I think that probably has a lot to do with what we were hearing from young people who participated in the virtual hearings. So while some of them did say that it was less, and they had less anxiety participating virtually because they didn't have to be in the room, in a courtroom that might be intimidating at times, we also heard that they would rather be in person than virtual from the young person's perspective, or at least have that choice. And then we also asked parents, attorneys and caseworkers and youth what was difficult about virtual hearings for parents and youth. And overwhelmingly, of the parents that we surveyed, overwhelmingly, they said nothing is difficult, like 89% of them, I think. And this goes to what I mentioned earlier. Everyone who was participating in our survey felt comfortable enough with technology to respond to my electronic survey. Had I do this again, well, I will do this again, and I will not do an electronic survey because I think that was problematic. Because there's a whole slew of parents that we know who may not feel comfortable participating in or feel that comfortable with technology. And I feel like I'm missing their voice here. So that's something that I would like to improve on in my next round. And both attorneys and caseworkers said their number 1 and 2, what was most difficult, lack of equipment and lack of internet access. Youth said it was hard to hear everyone speak, that it was hard to follow sometimes, and sometimes it was it felt less organized than in-person hearings. And then finally, we asked, what would you rather do? Online, no difference, or in-person is better? And again, the blue diamonds are for Nebraska. So half of the parents in Nebraska said that they would like to be online, and 28% said no difference, and 22% said in-person was better. The number of parents in Nebraska, our entire sample was only 51 parents. The number of parents in Nebraska was very small. So that's with a grain of salt. But for attorneys in Nebraska, 71% said it depends on the type of the hearing. And that's very similar to caseworkers. 48% said it depends on the type of the hearing, which is very similar to what we heard from court professionals across the country, that there are specific hearings that are better done in person versus virtually. So you can see that here on kind of our takeaways. 83% of caseworkers across our entire study think that termination of parental rights should be in person, and 64% think that adoption should be in person. 66% of attorneys think that TPR should be in person, and 44% think that adjudication hearings should be in person. So there was a little bit of overlap with the termination of parental rights, but there was not, they didn't both agree on what was kind of the most important hearing types. And what we're seeing is that some states are issuing that specific hearing type guidance around what types are allowed to be in person, or where the option is possible. Some of the considerations for the future in terms of recommendations we have for courts is making sure the courts have instructions to send out ahead of time and that everyone's getting the same instructions. We heard from some parents that they were only receiving phone numbers from their attorneys, and they weren't able to access the video. We heard from some youth that they were getting instructions from their caseworkers, and sometimes that was wrong and caused them to either be late or not be able to participate in a hearing. So making sure that the court is kind of guiding those instructions is important. We have some examples that will be in our resources on our website. And then acknowledging the virtual hearing, as I mentioned, just saying this is a virtual space, it's different, but it's still a hearing. I think acknowledging that and being transparent that there is some differences communicating online than in person. And that also giving people an opportunity to check that their audio is working, that they can hear and be heard. Then finally, here in Nebraska, I saw more hybrid hearings by accident. I wasn't supposed to see them, but a lot of times I would join a hearing and some people would be in person. And so a lot of courts across the country are moving towards that hybrid environment, some people in person and some people on the computer. And I think making sure that the courts have the infrastructure to effectively conduct a hybrid hearing is important. So by that, I mean making sure that there's an opportunity for people in a courtroom to see everyone who's on the computer, and for people on the computer to be able to see who's in person. In our technology department at NCSC actually has some resources available online. and our pandemic website that about what kind of technology is necessary in courtrooms to help that happen well. So I'll just leave you with this. We have a couple publications that will be coming out on access to justice, best practices in trauma responsive virtual hearings. And then we are writing one specifically about what we heard in our interviews with young people to kind of elevate their voices around what their experience in virtual hearings is. The virtual hearing environment talks about making sure that your camera is set up in a way that you can be effective and so on. And then we have, as I mentioned, the webinar on family drug treatment court. We have a next phase of the study that is going to be starting very soon, and some of the things that all of the things that we're hoping to learn are questions that came out of our first phase. So our first phase was exploratory, just kind of dipping our toe in to see what was happening, and then we've generated some of these questions. So we'll be, as I mentioned, collecting a lot more information from parents in a variety of different ways. And we'll be able to see some differences in case outcomes now that we're this far into the pandemic. We're going to be looking at the efficiency of virtual hearings. So do cases close faster? Do hearings start and end on time? Things like that. Language access, as I mentioned, hybrid hearings, I mentioned. And then we have some opportunities to look into courts who are providing access to technology either in the courthouse or kind of leasing out devices to parents who don't have that resource. And so we're going to be looking into how that, has that increased people's ability to participate in the virtual hearings. So that is all the information I have on my work so far, but I'm happy to answer any questions.
Are the resources that you have on your website accessible to people who are not?
Oh, yeah, that's a good question. So the NCSC website is open to anybody. The resources that we're working on here, they're not out yet, but they will be very soon. These are in development right now. And NCSC at the beginning of the pandemic started what they called the Rapid Response Team, which was a group of chief court administrators or state court administrators and chief justices. Corey Steele is one of the members of the RRT, and they have a wide range of resources about all different case types and all different kind of dimensions of courts that's available right now on the website. So it's ncsc.org. And if you just go there, I think it's right on the homepage, pandemic. It says pandemic resources, and you can click on that. And these will be coming out soon. The Family Treatment Court webinar is available on that pandemic site right now.
Did you say that you will still have to do a study then on the best practices? I'm saying this is the second block you've done. Best practices in trauma response virtual hearings. These
are the publications that we're writing based on our study that we have completed. So that is in process. Yep. So that is those will be recommendations because it was just exploratory. So we can't say that this made a difference, but we can say based on our experience or our observations, here are some things that you should consider doing in your virtual hearings to make them more trauma responsive.
Okay, so all of the 5 boxes you've got up there will be based off of data that you've already collected?
Yes, yes, ma'am. And then these are the things that we hope to learn in the future. Okay, well, thank you. I'll be over there if you do have a question. Thank you.